because it gives us rights that we hold against government. These rights don't come out of any regulations or statutes. These are actually rights that are constitutionally ensconced. So law professors teach the public trust as part of environmental law. It's been considered sort of the law's DNA because it's present in every single state in this country. It's been present since the inception of our country. It's been affirmed by the Supreme Court of the United States several times, and it's in other nations across the world. It actually goes back to Roman law. And the logic of the trust is very simple. What it says is that for our essential resources, meaning water and air and wildlife and shorelands and so forth, those essential resources have to endure. And so they're considered to be in a trust. You can think of it like a college account for a certain purpose. Well, this is a survival account for humanity. And government is a trustee of that trust and must manage it for the benefit of the true owners, who are the people. And so every single case on this says the beneficiaries are present and future generations of citizens, and the government is the trustee. And as trustee, it has certain fiduciary obligations to protect that trust. Well, a Supreme Court case back in the 1800s said that, very famous case, Illinois Central, said that government just can't convey these resources out to private hands. To do so would be a grievance which would never be borne by a free people. So the thing to know about the public trust is it is bedrock law. It is constitutional law, so it can't be overturned. It's really the last law standing in a Trump administration. It's the one, forgive the use of the term, it's the one source of law that could trump Trump. Here's a cartoon about the public trust, and I don't know if you can kind of see all this, but you've got some people drilling, doing fracking on the left-hand side, and then they're pointing down their drill, and then on the right-hand side, they say, we've hit something impenetrable, and that's the public trust. And the reason it's impenetrable is because it's the doctrine of constitutional dimensions. Statutes can be changed by Congress, but Congress and state legislatures are subject to the Constitution. We, the people, hold the rights under the Constitution. A very famous case came out just a few years ago from Pennsylvania. It was a fracking case, and the Chief Justice of that court wrote 72 pages on the public trust and found that this is an inalienable right that we hold, you all hold. And he said all citizens have inherent and indefeasible rights that are of such general, great, and essential quality as to be ensconced as inviolate. So these are the rights we hold against our government officials, but how can they be enforced? They can only be enforced in one branch. And what is it? Courts. So we're really back to our civics lesson from 5th grade. We've got 3 branches of government. We've got inalienable rights, but only courts really enforce those rights against the other 2 branches. So back in 2011, the group Our Children's Trust took this doctrine and did something that had never been done in the history of law. They created cases and sort of a hatch of cases. You can think of it, egg hatch or bug hatch, whatever. It was a hatch of cases in 1 week across this country and then later in countries around the world. And these cases were brought on behalf of youth against government in states across this country and then in other nations. And what they asked for, based on the public trust, these youth said, government, you are our trustees of the atmosphere and the climate system. That is in the public trust, just as the waters have been declared by many courts to be in the public trust. And as trustee, you have to protect the atmosphere and the climate system for our survival. In other words, you can't just take this beautiful natural endowment that supports human survival and has done so for thousands of years. You can't just take that endowment and drain it and give that endowment to the fossil fuel companies. That is impermissible under the public trust because it belongs to us. The air, the atmosphere, the climate system belongs to us in stewardship. So not a private property right, in stewardship, in trusteeship for future generations. And these cases at first At first, the court said, you know, it's not our job. This was back in 2011, and the judges were saying, in various states, not our job. And here in the state of Oregon, the trial court in Eugene, Oregon, said, not my job. It's the Oregon legislature's job to deal with climate. And the courts were treating this rather as a hot potato. Not my job, legislate. Well, of course the legislatures have. Of course it is their job. That's the whole point of the litigation, to enforce the obligation that the legislatures have. But the judge in Eugene, Oregon said, not my job. Went up to appeal. He was reversed. The Court of Appeals said, you do have to determine whether the youth have a public trust right. Came back to him, and the Oregon trial court judge said, there's no public trust in air, wildlife, beaches, he even said waters. And so he basically put Oregon on the far, far, far end of the spectrum with the most minimal public trust declared rights. That is on appeal. I expect it will be reversed at least in part. But that's your Oregon case. But elsewhere, courts started changing, and these cases started winning. And it may well be that the Oregon case will turn out that way too. It's in the Court of Appeals right now, so we'll find out at some point soon. In Massachusetts, a big victory, where the court declared that the Massachusetts state wasn't doing enough to lower carbon emissions. In Washington, just to the north of us, an incredible ruling by a trial court judge up there, Hollis Hill. And she was one who just came out and she read the science, and she said, global warming causes an unprecedented risk to Earth. Petitioners assert, and this court finds, their very survival depends on the will of their elders to act now decisively and unequivocally to stem the tide of global warming. And so this was a judge who said, this imperils the children's survival. She was looking at kids in her courtroom. The kids just pack the courtrooms in all these cases. So the judges are looking right in the eyes of the youth who hold the moral authority. And it didn't sway the judge from Eugene, Oregon, but, that judge, the state court judge. I'll tell you about the other judge from Eugene, Oregon momentarily. But it did sway, it has swayed many judges, and they've read the science, and so there have been victories. In other nations, in the Netherlands, huge victory, same with Pakistan. So now I want to tell you about the other case from Oregon, which is a federal case. In 2015, the organization Our Children's Trust filed a case against the Obama administration, challenging literally the entire fossil fuel policy of the United States of America. Because you see, anything else at this point, anything less, really doesn't accomplish what we need. We need to pull that ripcord in a big way and transition this energy system as fast as we can. And so this case was filed, and in pages and pages of a complaint, the attorneys for Our Children's Trust detailed the knowledge that the government had about how dangerous this fossil fuel policy has been for decades, and also detailed how the fossil fuel policy really works, how it is carried out on a daily basis through permitting and leases and export projects and so forth. And they said defendants have acted with deliberate indifference to the peril they've knowingly created. Well, this case, these are the two lead plaintiffs. Kelsey Juliana is one lead plaintiff from Eugene, Oregon. And this case has 21 youth plaintiffs, one of whom is here tonight, Jacob LaBelle. So you'll see him right after me. There's Jacob right there. Raise your hand. So these are, these are 21 youth plaintiffs from across the United States of America, all in this case suing the United States government for the entire fossil fuel policy. Multiple U.S. agencies are defendants. And the entire fossil fuel industry intervened through trade associations. So talk about a David and Goliath sort of case. It's big. And now, of course, President Trump is the lead defendant, replacing President Obama. It has been called, I think for good reason, the biggest case on the planet, because it involves literally a matter that will determine the conditions supporting survival on Earth for all foreseeable generations. So this went to the Federal District Court of Eugene, not to be confused with the other case I mentioned, which was the state case in Oregon. This case is a federal case, and it was filed in the Federal District Court of Eugene. And 2 days after the election of President Trump, Judge Aiken came out with a ruling, Federal District Court Judge Ann Aiken. And she said and recognized, this is no ordinary lawsuit. It was filed basically on 2 grounds that I'll summarize, but one has more than I'm going to be able to get into. But one was the federal public trust. The attorneys and the youth say that the atmosphere is in trust and the federal government is a trustee of the atmosphere and has the obligation to protect it for the future. The other claim, which had not been in the other public trust cases, was a claim under the United States Constitution. Basically, and I'll just summarize here, saying youth's rights to life, liberty, and property, that are guaranteed rights under the Due Process Clause of our Constitution, those are jeopardized by the government's actions. So it was a dual trust claim and constitutional claim. And 2 days after the election of President Trump, Judge Aiken came out with an order that delivered a resounding victory for youth on all of those claims. Huge victory. She found that the federal government is a trustee of the atmosphere. She found that there is a constitutional right to a healthy atmosphere. And this is language from the opinion. She said, I have no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. So this is, it puts Oregon in the position of, with that parachute, of having a huge ripcord, because this is the first declared right under the U.S. Constitution, and also she interpreted the federal public trust as a constitutional right. So it's a constitutional right to a healthy atmosphere. So as you go home tonight thinking of all the constitutional rights you may have to equal protection and due process and right of privacy and right to travel and all those things, think of this one. This one is the declared constitutional right to a stable atmosphere. That is huge in the law. So now the case goes into trial. The fossil fuel industry and the government has both filed a request with the district court to allow an interlocutory appeal, which would put it up on appeal prematurely. Those are normally denied. They're often tried, but they're normally denied by courts because the law has a logical process for dealing with lawsuits. And what happens is there's motions to dismiss. The youth have passed that stage and won, and then they go into trial, and then from the trial there's an appeal. And so we don't know how Judge Aiken will rule on that yet. She just got the briefs. But that's something to keep track of by going to the website of Our Children's Trust. But assume it doesn't go on appeal, and as I say, these rarely are granted interlocutory appeals. People are calling this the trial of the millennium. Why? Because for the first time in the history of this country, you will have the fossil fuel policy of the United States meeting climate science in court. That's never happened before. Everything you know about climate is through a report here, an investigation here, a news article here. Never has the U.S. had to justify its fossil fuel policy against climate science in a court of law. Now, a court of law is different from a legislature. A court of law has standards of evidence. It's an objective forum. Legislators are not held to those standards. So the next step right now, in preparation for this trial, and the trial, I believe the judge said would happen in late summer or early fall, but the next step, the step right now that they're involved in, is discovery. These are 3 of the plaintiffs, and they have asked for, all the plaintiffs collectively have asked for a deposition against our Secretary of State, Rex Tillerson. And one day, he was, of course, CEO of Exxon and on the board of American Petroleum Institute. So on one day, he was one of the figures of the defendant interveners. The American Petroleum Institute was a defendant industry intervener. And Rex Tillerson was a figure in that capacity. The next day he became Secretary of State. And so this deposition would be quite interesting. And I'm not sure when it's going to be scheduled. If it's going to be scheduled, there are some legal matters to work through because his capacity has changed. Now, at the same time, our Children's Trust is moving very rapidly to file lawsuits across the country, other lawsuits across the country and across the world. And so lawsuits are either planned, being formulated, or pending in all of those nations. Last week, a 9-year-old in India filed a major lawsuit based on public trust against her government. India is one of the biggest fossil fuel polluters on Earth, and it has a very robust public trust doctrine. The Supreme Court there writes poetically about the public trust doctrine. So this is a massive suit in India. And what our Children's Trust now hopes for is that the green judicial dominoes will start to fall and fall in time. James Hansen, one of the foremost climate scientists in the world, says this about the litigation. He says, judicial relief may be the best, the last, and at this late stage, the only real chance to preserve a habitable planet for young people and future generations. League of Women Voters was crucial in that Juliana case that I just told you about in the victory. The League of Women Voters actually submitted an amicus brief, which was beautifully written, went into the history of American jurisprudence and really, really underscored the role of the courts. So I am going to wrap up and then let Jacob take the stand, but I want to make a couple of closing remarks. And that is that we live in a state, it's one of the few states that is not ravaged by the fossil fuel industry, and we have quite a legacy. We have an enormous natural legacy that all of us have benefited from. But we also have a legacy that's maybe even more important in the scheme of things, and that is we hold this moment in time where we are positioned as the citizens of the state to exercise our citizenship in a way that will influence the course of climate crisis and history to come. And so I urge you as you leave this room to just remind yourselves that we are the ones. Our grandparents had no idea of this crisis, and our grandchildren will know of it certainly, but will be too late by then to act. We are literally the ones to decide which future will evolve. And so as we leave this room, I always ask people to consider this moment, claim this moment collectively, and Oregonians are doing that, and to recognize that we together, the living generation on Earth right now, hold not the power of life, but the trust of life. Thank you so much. So now it's my honor to introduce Jacob LaBelle, who is a youth activist and reporter for environmental and climate change issues.